and welcome everybody to this event. I'll commence by acknowledging the Ngunnawal and Ngambri people, the traditional custodians of the lands upon which we, the ANU here in Canberra today, are meeting, and pay my respects to the elders past, present and emerging. Good evening everyone, and welcome to this inaugural event of the 2022 ANU College of Law Research Showcase Series. I'm Will Bateman, for people who don't know me or people who are joining us in the hybrid format tonight, and I'm the Associate Dean of Research at the ANU College of Law. Unfortunately, our Dean, Sally Wheeler, couldn't be here tonight, so I'm doing the welcome honours, but Sally has been instrumental in setting up this series and passes on her thanks to all of you for coming. The objective of this series, as the name suggests, is to showcase examples from the portfolio of excellent research coming out of the ANU College of Law. The events will focus on showcasing significant new publications such as monographs and articles in field-leading journals. Of course, we can only cover a small proportion of our colleagues' prolific research outputs in this series this year, and it is one which we hope will grow and develop in years to come. I do hope, however, that tonight's inaugural event in the series provides a glimpse into the diversity, breadth and quality of our research footprint. It also brings people together to discuss the great ideas and to celebrate the work and achievements of our colleagues and peers. We could not do better than commence the series with a presentation by Associate Professor Moeen Cheema. He'll be speaking about his book, Courting Constitutionalism, The Politics of Public Law and Judicial Review in Pakistan, which was published by Cambridge University Press in late 2021. The book discusses the evolution of judicial review in the superior courts of Pakistan and places it in a broader political and constitutional context. Moeen's book has been released to critical acclaim. As one reviewer noted, it is beautifully written and meticulously researched. Another described it as a, quote, landmark contribution to the study of public law and a truly magnificent work. Whether or not you read the book, I'm sure many of us will appreciate the opportunity to hear about its main arguments from the author and the force of his ideas. The event series has been organised by Dr. Anton Moiseyenko, who's a recently joined colleague at the ANU College of Law and has done a marvellous job in putting this event and the series together with the support of Associate Professor Faith Gordon. Without further preliminaries, I can thank you all for coming and hand over to Moeen for his presentation.
Well, thank you very much for organizing this and giving me this opportunity to talk about the book and some of the work that went into it over a long period of time. This book is based on my PhD, and if I were to be a bit polite, I would say it was a labor of love. But what that means is I took my sweet time with it, and I partly blame Pakistan's courts for it, for issuing thousands and thousands of public law judgments over the 70-odd years of Pakistan's post-colonial history. So not all fault was mine. We do have Peter online, do we? Yes, because it's a great opportunity for me to acknowledge and thank Professor Peter Kane, my supervisor, who was mostly very, very patient with me. But at one point, even he did get frustrated with me a little bit because I was going down all these theoretical rabbit holes like rule of law theory and governmentality analysis. And Peter sat me down, and that's probably the best description of the book, which is why I'm relying on him. And he basically said, look, it seems to me all you're trying to do here, which is a significant project in its own right, is write a history of the courts in Pakistan, how they went from relatively marginal state institutions in the times of the colonial to post-colonial transition of Pakistan to what seems like really, really powerful and at times highly activist judicial institutions, especially the Supreme Court in more recent times, and a very central player in Pakistan's constitutional politics, not just constitutional law, but also constitutional politics and state structure. So why don't you just write that history? But more importantly, which was an even bigger challenge, and here I'm almost quoting him directly, he said, when people write histories, sometimes they can be one bloody thing after another. And that is probably very apt for the Pakistani context. So what you have to try to do is to find some framework, some way of explaining how and why this transition happened over a period of time in Pakistan's post-colonial history, how these courts became powerful, and in a way that is intelligible, which is, which explains more than, certain other aspects. And that to me was the real challenge, because on the one hand, I was really trying to complicate some fairly simplistic narratives, and I will go into that, just in a little bit, about judicial power in Pakistan and Pakistan's constitutional history. And at the same time, I had to find some way of making it somewhat simpler and intelligible. Pakistan's constitutional history is superficially, literally one bloody thing after another. But the most interesting part about that is, unlike many other places in Asia where judicialization of politics has happened, for example, or in Africa, or in Latin America, it's a very interesting case study because we get to see how courts behave in multiple regime times. So this history of constant constitutional and political change and change in regime types enables us to study how these courts, what role have they performed, why have they performed certain kind of functions more than others, how they have gained in power over time in multiple regime times. If I was to just stand here and tell you just a chronological history of, broad overview of constitutional history of Pakistan, we would be here for the rest of the evening. But, some of the more interesting examples are just, the early transition from colonial to a post-colonial regime in South Asia after separation or partition of British India at the time of the end of colonial rule, whereas India managed to become a republic and have a stable constitution, at least juridically, stable de jure constitution over a long period of time. Pakistan fails to come up with the first constituent assembly, which was not directly elected, failed to come up with a constitution until 1956, precipitating the first major constitutional crisis in the country. And even when that 56 constitution was passed, it lasted only 2 years without actually ever being fully implemented until Pakistan's first military coup and extended period of martial law. It was a very interesting regime type because very quickly, this Eastminster style dominion, that is what it ended up being in the absence of a constitution, it became an instance of bureaucratic authoritarianism, literally a state very much like the colonial state, which was run by and dominated by the apex bureaucracy, the civil service of Pakistan, which was the direct descendant of the Indian civil service. Over time, Pakistan has had 3 significant extended periods of direct military rule, martial law, followed by some kind of in each instance, different semi-transition to a presidential or a quasi-presidential military regime with some sort of civilian facade or some kind of a hybrid regime where the military still remained the dominant player, and then ultimately followed by that in a very, very cyclical way, 3 cycles, followed by a transition to formally democratic, highly fractious, characterized by significant political contestation and quite a bit of instability, at least in 2 instances in the 1990s and the more recent period, formally democratic civilian rule. So these constant movement of, moments of transition from military or civil authoritarianism to supposedly civilian, formally democratic rule. So here were these courts that were constantly engaged throughout Pakistan's history in managing these transitions or being called upon to adjudicate upon these transitions. In all 3 periods of military takeover or military coup, Pakistan's courts validated the military takeover based on some really, really interesting and novel doctrines. Doctrine of revolutionary legality, doctrine of state necessity, trying to go back into some obscure concepts in English English common law about, martial law, military rule. For revolutionary legality, they deliberately maybe not deliberately, but blatantly misquoted Hans Kelsen to justify that once the military has taken over, that is a revolution in reality. So the new military regime can do whatever it wants because it's an entirely new constitutional scheme. And over time, that has painted this narrative, justifiable to a great extent, of these courts that were weak, that were complicit, particularly in military rule, did not have the capacity to push back against the dominant, largely military or at times, bureaucratic power in the early stages. So this narrative of courts that were complicit in the power structures dominated by the military throughout much of Pakistan's early history. The last period of military rule was from 1998 to 2008 under General Musharraf, so it is still fairly recent. Now, fast forward to today, and Pakistan has had its longest period of formally civil democratic rule. 3 elections starting from 2008, the transition from the Musharraf regime to onwards. 3 governments have taken over power, so there has been fairly peaceful transitions, although highly contested because of questions about electoral manipulation or rigging. But we've had 3 governments that have taken over power or had transitions from one civilian government to the next through elections. But no prime minister has managed to complete their term. So for example, in 2013, Prime Minister Gilani, in the last year of his parliamentary term, so the parliamentary term is 5 years, booted out by the court because of charges of contempt of court. And the court built this whole narrative against the government, which managed to get the next government into power, or at least facilitated the ground for them. But then Nawaz Sharif, who was 3-time Prime Minister of Pakistan, has never managed to complete his parliamentary term, 2 of them back in the 1990s, was again booted out by the court in 2018 in the aftermath of the Panama Papers leak where his family's assets were highlighted through held through offshore companies in the UK and elsewhere. And once again, it was the court that dismissed an elected prime minister and sort of paved the way for another electoral transition. And most recently, if you've watched the news, Imran Khan has just become the first prime minister in the country's history to be booted out through a no confidence motion. But again, the court was instrumental. It wasn't the main player dismissing him from power, but was highly instrumental and will continue to be instrumental in this current episode of political instability which is going on in the country. So that lends itself to some really easy historiography of courts in Pakistan. Here were courts that historically were relatively weak, particularly in the face of the real power structure which was dominated by the military. And all of a sudden from 2008, 2007, 2008 onwards, as if they had woken up and in almost an ahistorical fashion just become so powerful that they could dismiss elected prime ministers and be highly activist in a whole range of new domains, such as in anti-corruption and on key constitutional issues, such as this is the very epitome of judicialization of politics to many people. Courts being involved in governmental and regime change. So that lends itself to that easy history. Again, in a lot of discussions about Pakistan, the focus remains on the big constitutional crisis because that is so easy to do because there have been so many and repeated constitutional crises. So this narrative of political instability in which courts have become increasingly involved and actually a key player in causing or mediating those constitutional crises. Also sometimes lends to this kind of glorification of judicial review and of courts. These historically weak and meek courts all of a sudden becoming just the banner holder of rule of law and of democratization, getting involved in these big issues of constitutional politics and trying to make the civil democratic governance in Pakistan more democratic, more substantively democratic. So that also sometimes lends itself to that sort of narrative. Often in Pakistan's public discourse, there's a lot of discussion about specific events and of personalities and very overt politics, such and such chief justice or such and such prime minister. But when we're talking about the courts, a lot of focus on judicial personalities, on individual decisions. So the challenge for me was, in some ways, to actually look a bit deeper, come up with a deeper description, because in my mind, this was not merely these constitutional crises, these events, these cases are significant, but to me, there's a deeper history which also needs to be told. Without taking too much away from this focus on the big constitutional cases and crises, from my point of view, there was a deeper history to be told. These courts did not just become powerful out of nowhere in 2007 or in 1990 for a brief period. There was a much deeper and longer history which also needs to be told. So kind of complicating the narrative, while at the same time trying to simplify it. And one of the core arguments that I make is that the deeper bedrock of judicial power in Pakistan and of judicial review in Pakistan is very much rooted, not necessarily in constitutional law. When these crises happen, these big cases come, that bubbles to the surface. But the deeper bedrock of judicial power in Pakistan lies in writ jurisdiction, or the so-called writ jurisdiction, or in administrative law, broadly speaking. So it's a much bigger story of public law rather than just constitutional law. It's in a much more deeper, meaningful way, it's a story of judicialization of governance, more so than a story of judicialization of politics, if I were to frame it in that way. We often talk about independence of judiciary, and when most people, particularly in Pakistan or discussing Pakistan or South Asia more broadly, think about conceptualize independence of judiciary in terms of the judiciary being independent or relatively independent of other state institutions and being able to push back the pressure from, say, an elected executive, or in Pakistan's context, the military. But while that might be the case, these courts have always been involved in issues of structural politics. They've always been political courts, one way or another, and they're deeply embedded in the state structure. I want to channel Upendra Bakshi's very poetic phrase that he used a while back. At the end of the day, they are state-bound, state-permeated beings. They're not independent of the state. The primary, or the most often the job that they do on a day-to-day basis, in between, or in the interim between these crises, is being involved in issues of structural politics. What is the state structure? What does the bureaucracy look like? What are police powers? Compared to those constitutional crises, you might say, relatively more mundane issues of governance and of administrative law through the writ jurisdiction. And there's a very, very much long history and much deeper history of that. So I actually want to tell you a story which I found very fascinating when I was looking at Pakistan's early constitutional history. At the moment of transition from bureaucratic authoritarianism back in 1958 to 62, first period of martial law, to me, how the courts behaved during these periods of martial law is actually in some ways more informative of what their core functions are, or how they conceptualize or historically have conceptualized their role and their core functions. Hence my argument about the bedrock being in the writ jurisdiction rather than in these big constitutional cases. So Sir Edward, this is a story about Sir Edward Snelson, one of the last two remaining British ICS officers who remained in the civil service of Pakistan. And he was the secretary of the law ministry at the peak of military rule in 1960. Sir Edward Snelson made an official speech, which was actually covered by, at least nominally covered by, the Official Secrets Act, which means this was not a public speech, although copies of the speech were widely distributed amongst the bureaucracy, and in which he said a couple of really objectionable things from the point of view of the High Court, what then was the West Pakistan High Court, because he basically said that under Pakistan's 1956 constitution, which had this interesting phrase that the court can issue any writ in the nature of, any order in the nature of a certiorari mandamus, and the naming all the writs, something that the 1973 constitution has now ditched, but back then in the early post-colonial period, mentioned the name writs, but the phrase was in the nature of. And the West Pakistan High Court kept trying to expand its writ jurisdiction, newfound writ jurisdiction, because it did not have a writ jurisdiction under colonial rule. The high courts didn't, apart from the writ of habeas corpus, which was in the Criminal Procedure Code, or a version of it. There was no prerogative writ jurisdiction, and it's only the 1956 Constitution which for the first time gave the courts that power using that phraseology. So the West Pakistan High Court kept trying to push the boundaries on interpreting in the nature of, meaning orders in the nature of, but we're not necessarily bound by the various limitations in English common law. And so Sir Edward Nelson found an objection to that, arguing that what the court was doing was objectionable because it was making no reference to the strictly defined frontiers of the prerogative writs. It's a fairly arcane sound language to me at the moment, but the next phrase that he used sounds very contemporary to me, because every time the courts become a little bit activist, this is an objection that you hear either from the military, but more often from the civilian governments, is that they were interfering in and even usurping executive functions. That was the basis of the contempt of court case, and the High Court found him guilty. What is interesting is the law secretary was quite justified, at least on one level, because the Supreme Court had on at least 12 occasions in very prominent cases had struck down High Court decisions precisely on that same basis, that they were going beyond, they were interpreting the constitutional language too liberally, and were interpreting and were going beyond the strict frontiers limitations on prerogative writs in English law. But even the Supreme Court upheld the conviction and found the law secretary guilty of contempt of court. To me, that's a significant moment marking the courts as defining the contours of the writ jurisdiction or their judicial review powers as solely for them to determine without any executive or external interference. That's a model that the courts have used in every period of even direct military rule or even indirect military rule, is where, when they have been faced with a strong executive in the form of a military regime, either directly under martial law or indirectly, they've gone back to what they define as their core functions, which is the writ jurisdiction. And they've done that in every significant period of, as I said, military rule, whether direct, even under martial law, when according to them, there is no constitution. One key question, how and why did that happen? And more importantly, why did the military regime let them get away with it? And in each period, we find that there was a certain level of alignment between the military and the courts. And that alignment was based on one key principle, because the military was also trying to assert its dominance over the civil bureaucracy, the police, the civilian institutions, regulatory bodies, over time as the modern administrative state emerged. And providing some kind of judicial review fell in line with the military regime's priorities to that extent, so long as the courts did not challenge their core political and strategic interests. But in every period of transition from military to semi-civilian rule, and then ultimately to civilian rule, as I said, very broadly laid out that cyclical history, the courts built on that core jurisdiction and became way more activist during periods of civilian rule. So what we have over a long period of time is what I've somewhere else described as the non-linear expansion of judicial power. So while in each period of military rule, they went back to what they define as their core jurisdiction, in each subsequent period of military rule, they were relatively more assertive than the previous period of military rule. And then each period of civilian rule, after transition from military regime or a quasi-military regime to civil democratic governance, they became even more assertive. And in each period of civilian rule, more assertive than the previous period of civilian rule. So hence, this almost like a step, what I can only define as a non-linear expansion of judicial review. So what explains this fairly consistent, though non-linear trajectory of Pakistan's courts exercising public law jurisdiction, which is the 4 provincial high courts now, and the Supreme Court in this fairly consistent but non-linear fashion. If we look at the basic, the big paradigms that explain judicialization of politics around the world, this might sound like a mundane conclusion, but Pakistan doesn't seem to fit very well into any such big framework. One way of looking at it, one argument that comes up again and again is this increasing judicialization of politics around the world and judicialization of governance, particularly in South and Southeast Asia, that we have experienced in more recent times, is part of the great liberal trajectory of the post-Second World War rise of rule of law and first rights, and then rule of law and courts becoming more involved in these issues. That does not explain the Pakistani story. That seems to be the one explanation that seems to be one can dismiss right off the bat. For example, the Supreme Court's original jurisdiction under which it can take up which the court has used increasingly over the last decade or so, nominally, that's a rights jurisdiction. The court can take up any matter of public importance with regard to the enforcement of fundamental rights. So nominally, every case is a case of fundamental rights, because that is the only way the court can assert its jurisdiction. But if you look at the court's actual rights record, it is very, very patchy, to say the least. It is minimal, particularly when it comes to minority rights, women's rights, religious minorities and their historic concerns. The track record is very, very patchy. The court has been a bit more, broadly speaking, assertive when it comes to issues of what they define as rule of law, abuse of police powers, abuse of judicial process, etc. On certain occasions, enforced disappearances by the military or security agencies, but only occasionally. There, the court's record is much better, but referring to rights and rule of law more broadly just doesn't provide us with much explanatory power. I think two ideas which have been quite prominent in the judicialization literature, they provide, at least at times, much better explanations. So one is, for example, Rand Herschel's very, in many ways has been an influential idea, which is the so-called departing hegemon theory, is that when a regime change happens, it is in the interest of the departing hegemon, and in Pakistan's case, it is relatively easier to identify the military as the departing hegemon, that builds in or provides support to judicialization to safeguard whatever the entrenched interests are, particularly in the domain of socioeconomic policymaking or into democratization, from the vagaries of electoral politics and from from elected governments and democratic governments. That has happened in times of transition. So that kind of idea, and that the courts then tend to align with the dominant elites, the classes that are likely to be on the losing side once democratic politics takes a deeper hold. That sort of idea does play out in those moments of transition, particularly from military rule to formally civil democratic governance. But I don't think that fully explains a lot of the longer trajectory, the longer history. There's another functionalist paradigm. People like Tom Ginsburg and Tamir Mustafa also did a wonderful book on rule of law under authoritarian regimes. That tells, I think, in many ways, a deeper story. The deeper story of courts being a more strategic, more overtly strategic political institution whose primary interest remains to enhance their role, their power over time, if they can get away with it. When are they able to get away with it? Is not necessarily when, obviously and understandably, not when there's a strong elected or a dominant military regime. They manage to do that at moments where politics is extremely fractious. There's no one political actor, one political player or an institution that is able to assert its dominance. And that creates the space for the courts to bring about a kind of judicial creep over time. Often what happens is, and the Pakistani story bears it out, is that because these issues become so contested, that by default, these matters fall to the courts as almost like the last legitimate arbiter of these kinds of issues, which can diffuse those tensions. And by mediating those political tensions, by mediating those transitions, and trying to diffuse some of the political energy that these crises entail, the courts are able to assert in a creeping fashion, greater jurisdiction, greater power, becoming in a fairly strategic, not necessarily in a benevolent way, maybe not necessarily in a self-serving way, but becoming more and more prominent in moments when politics is characterized by a lot of division, and there's no political player which is able to assert complete dominance or hegemony, and some of these issues become deeply contested. Another very interesting dynamic that the Pakistani story helps us identify in terms of judicialization is courts have also acted as a political institution in the sense that they have catered to certain constituencies which have changed over time because of the changing class dynamics, particularly in and around the state. So groups and classes, elites that have become more important and influential and assertive over time. So historically, the courts, for example, in the early periods, the primary constituency used to be the bar. A very big oversized bar was, of course, a legacy of the struggle for dominion status during colonial period, where most of the politicians were also lawyers. Very an oversized bar and more politically prominent bar was it used to be historically its prime constituency. Over time, that has changed. From the 1990s onwards, for example, Pakistan's fairly limited, relatively speaking, urban middle classes, especially the educated urban classes, the managerial classes have become more and more prominent constituency along with the bar. More recent times, the media has also been added to that particular constituency. And at a particular period under Iftikhar Chaudhry, during the Chaudhry court's time from 2008 to 2013, and for a very brief periods afterwards, we've had the court, particularly led by a dominant chief justice, actually try to become populist. So try to garner a more populist, broader political constituency than these traditional support bases. And that seems to have an impact on what kind of issues become more salient for the court, whereas it's, for example, I talked about, certain kinds of rights issues remain very much on the back burner or are not salient or important to the court. So actually behaving like a political institution, looking out for its specific constituencies and the issues that are more significant to those constituencies. When courts, last bit that I would like to highlight is when courts have become really powerful, and now I'm increasingly starting to struggle with this term power. What does judicial power really entail, particularly relative to power of an elected government or an executive or the military? It's a very different kind of power. To me, it's a largely negative power, but I can leave that aside for questions or maybe some comments, right? When Pakistan's courts have become powerful, how have they exercised those powers? And my argument is there is a serious lack of imagination. So my argument is even when they have become really powerful, and even, for example, under the Chaudhry court, they even became fairly populist, deliberately populist, there's a serious lack of imagination. So from my point of view, when they have become powerful, by and large, all they have done over time is extended their jurisdiction and their role along the three axes of post-colonial legality, because that is what these courts inherited. And it is somewhat depressing at times is how deeply ingrained and embedded these ideas are in these institutions, not just the individuals, but in these institutions. And I'm also talking about the bureaucracy, to some extent the military, is how deeply ingrained these ideas become. And so even when they've had tremendous power, judicial power, which is a different kind of power, as I just argued, they've suffered from a serious lack of imagination. And so those three axes of post-colonial legality are, first and foremost, a basic kind of formal constitutionalism, trying to bring the political players back again and again towards what almost seems like a perpetual democratic transition towards formal democracy, elections, and mediating these political crises, as I mentioned earlier, so that the political system, the democratic political system, might continue to function in more recent times or in previous eras, to trying to transition from military or civil authoritarian rule to more formally democratic form of governance. So that's the first axis. Second, I've already highlighted in some detail, maybe I've hammered the point too much, is that their primary business has remained throughout Pakistan's history, the writ jurisdiction and administrative law. They've been involved in these issues of, what should the bureaucratic structure look like? And the key idea there is, again, harks back to the colonial bureaucracy. There's this idea that administrative reform or bureaucratic reform or rule of law in administrative law space, primarily the key idea seems to be, is a harking back to the integrity, the impartiality, the independence of the colonial or the early post-colonial bureaucracy. So trying to win the bureaucracy back, that independence and some sort of autonomy from the elected governments, again and again. That seems to be the core idea that they can't seem to depart from. So even when they have exercised tremendous power in that space, as I said, there's a certain lack of imagination. They might have extended their reach to these new, more recent statutory corporations and then these regulatory bodies, particularly in the economic domain. But the core idea remains again and again the independence of the bureaucracy and the rule-boundedness of the bureaucratic apparatus and some level of autonomy from the elected executive. And the third area in which they have continued to exercise a fairly robust jurisdiction, even at times under military rule, which I mentioned earlier is quite fascinating, is very old school colonial style rule of law concerns about the abuse of police powers, about detentions, about abuse of the legal process to file cases against dissidents or political opponents, and those very old school traditional rule of law concerns. So even when they've had tremendous power, from my point of view, all they have done is expanded those powers and their role along the lines of these three axes of post-colonial legality. Can I just leave it at that? Is that...
The next bit is I'm meant to share.
Yes.
Q&A, but I think you leave that one on. And well, thank you so much, Moeen. That was just fascinating. I've got lots of questions, but I'm sure other people here do. So I'll not exercise the chair's prerogative and go out to the audience and ask if there's any questions for Moeen, people who've read the book or who are just fascinated by the presentation today for our speaker.
So much for the presentation. My question, you kind of touched on it as you discussed some of the conditions in which the course became. I was curious if there have been any prominent instances of backlash against that growing power, and if this is something you perhaps might want to give us a sense of, because I'm sure it has not gone uncontested.
So under military rule, the second military regime, there was a pretty significant backlash. The backlash came principally in the form of altering the constitutional arrangement. So under General Zia, who took over power in 1977, and Pakistan remained under martial law until 1985 in that period. The courts continue to exercise that, what I define as the traditional rule of law jurisdiction against martial law, the use of martial law instruments against trials of dissidents, etc. And for a period, they thought they could get away with it because they were relying on the earlier, relatively more tolerant period of military rule. And the pushback came in the form of essential change in the constitution, which did two things: a judicial purge, or a threat of judicial purge, which happened. And secondly, General Zia's more interesting way of undermining the judiciary was to bring about an Islamization program of the state and of the laws, especially criminal laws. And he created these new judicial institutions, the Federal Sharia Court and the Sharia bench on the Supreme Court, mostly staffed by the usual judges from the high courts who were transferred over as a form of penalty, principally, sent off to the Sharia Court. But what the Sharia Court did, this new judicial institution, was something really fascinating. It took over what the traditional rule of law principles, for example, principles of natural justice, and they essentially rebranded them as fundamental principles of Islamic law, so that even this military regime then could not push back against those ideas. So by creating this new court, actually created a few more troubles. And the other key principle that they defined as a key principle of rule of law was, of course, judicial independence. Key principles of Islamic rule of law was judicial independence and the autonomy of the bureaucracy from the non-elected president. Have I answered the question?
I believe. I believe so. Anton, has your question been answered to your satisfaction?
I can add, but during periods of civilian rule, of course, that language which I said is really contemporary. Every time the court has been activist, elected governments have pushed back, and they basically have made precisely the same sort of argument that Edward Snelson made, which is that the courts are usurping executive functions, interfering, not letting the government perform, interfering in the executive domain. And elected governments have shown tremendous capacity to deny enforcement through one means or another to judicial decisions. So, which is why I briefly referred to the limits of judicial power.
We might go to a question from the online audience.
Yeah, I've got a few questions. The first one is, are there any comments on the efficiency of justice for non-political actors in 2008?
Sorry, what was the question? Efficiency of?
So the efficiency of justice for non-political actors since 2008, specifically for acting lawmakers.
Well, there was one. Well, so immediately after 2008, we had the period of the Chaudhry Court from 2008 to 2013, during which we had a highly assertive court, which took up a lot of cases, particularly around political corruption, about abuse of police powers, etc., and took a lot of those cases suo motu, which is, for anyone outside South Asia, people might actually struggle to understand what that concept is. Court taking up a case under its original jurisdiction of its own accord, without there being a petitioner, the court becoming effectively the principal party in initiating the case based on media reports or taking judicial notice of some public event. How efficient was it? The jury is still out on that particular issue. The court did take up a lot of these cases. It was very successful in highlighting those issues. And the pathology of Pakistan's legal system, of the bureaucracy, of the police, of the state system, but was it able to bring about a structural change? That the jury is definitely out. I don't think that I don't think that happened in any systemic way. So while these cases and this kind of judicial review is often quite successful in bringing certain issues to the public domain and highlighting these issues, in terms of actual efficiency of the bureaucracy, of the police, of the state, bringing about any meaningful change in institutional practices, I think the answer will have to be no.
question from the audience. Yes.
You mentioned there was a lack of judicial creativity in moving away from sort of old English common law values. Noting that it's hard to sort of characterize an institution's creativity and imagination, but what would you see as a vision then if that was to be able to be broken free of this?
So, even if you think about, administrative reform, that has been on the agenda, in the political agenda for a significant number of years now, especially in the aftermath of the Chaudhry Court, and especially since Imran Khan's government came into power 3.5 years ago, because that was a big, campaign pledge. There are all sorts of wonderful ideas about administrative reform, but the court has never pursued any of those ideas, in the context of a court that effectively, in a suo motu case, transforms itself into a public, commission of inquiry, and then also the adjudicator, and then, able to dictate at times even what kind of legislation needs to be brought in, what kind of reform needs to be brought in. So in the context of that kind of, relative power, to go back again and again to those ideas that the bureaucracy should be appointed on merit through the Public Service Commission, for example. The bureaucrats in case after case after case need to be shielded from undue pressure from the minister or from the government. Too many transfers, postings, demotions as punishment, or undue promotions, etc. They've just remained embroiled in case after case after case in these sorts of issues, rather than, as I said, being a bit more imaginative about administrative reform. And there are lots of wonderful ideas out there. Without,
I might have a follow-up to that question, a fabulous question, which, as you were describing that story about that British official who stayed on and then got turfed out because of an interpretation which makes a lot of sense to Australian public law ears about the hyper-technical potential of words like writs in constitutions, which in Australia has this long painful history with Section 75(5) of our constitution. And it just got me thinking about the stickiness of legal norms and the stickiness of public law norms, which is something that Peter Kane talked a lot about at one point in his career. What is it about these norms that made them so attractive to elites of different varieties that were seeking to entrench their power? Why was it an effective strategy for the courts to roll back or to sort of invoke these, notions of common law authority, which were, by the way, moving out of favour in British public law at exactly the time that the Pakistan courts invoked them to send a British person back? Was it just, or to hold him in contempt of court? I'm not sure what the end of the story was, but what is it about those sort of colonial legal norms in the Pakistan context that made them such an effective power and reinforcing strategy for legal elites and the ultimate, hegemonic elites that facilitated and let them flourish?
There's an easier answer and there's a more difficult answer. The easier answer is if you look at the early post-colonial period, and who are these judges? These were judges who were career judges or high court judges during the colonial period. And in 1956 is the first time, the first significant grant of the prerogative writ jurisdiction to the courts in that language in the Constitution. And so it's understandable to some extent is that these are the ideas that these judges were trained in. What is more fascinating is that the same Supreme Court, barely 4 years after Sir Edward Nelson's case, when the military regime brought in Pakistan's second constitution, a presidential constitution in 1962, and the military ruler gave up his uniform and got himself elected as a civilian president, then bought on to each and every argument that the High Court was making, which it had been denying just 5 or 6 years back, adopted all of those arguments. And so Pakistan's administrative law fairly quickly in 1960s started to move on from those ideas.
Away from the Ritz.
Away from
We're still
the
there.
technicalities of the,
They were 50 years ahead of Australia on that point. So yeah.
Another very fascinating similar story is that the 1973 Constitution in its original form gave the Supreme Court that original jurisdiction, that fundamental rights jurisdiction, take up any matter of public importance with regard to the enforcement of fundamental rights. But the first significant case in which the courts, an instance in which the courts really started exercising the original jurisdiction, modeling on the Indian Supreme Court, but the Indian Supreme Court had been doing that throughout, starting from the late 70s, throughout the 1980s. The Pakistan Supreme Court started doing that in 1989 at the moment of another transition from military rule to civilian rule. And that is where, for the next 10 years, just continued to very robustly exercise the so-called public interest litigation model. But that provision had been in the Constitution from the 1973 Constitution from the very beginning. It's only in the 1990s. So constitutional texts, to me, does not explain
a lot of this behavior. It's the kind of factors behind judicialization of politics that I was mentioning during the talk, which explains why the court starts using the provisions that are already there in a much more activist way in the 1990s, for example. So, but unlike the Indian Supreme Court, which has over its, at least in a certain period, perhaps not more recently, but for much of the 80s and 90s, had a much greater focus on the so-called social action litigation. Even in the exercise of public interest litigation in Pakistan, there has been, apart from the odd case, there has been very little focus on social action litigation. Again, public interest litigation has been about fairly traditional administrative law concerns. Negative liberty ideas. Yes. Thank you. Is another question online?
Another two questions online. The first comes from Holly, who's a PhD candidate joining us from China tonight. I'm very interested in the issue of judicialization of constitutional politics in your book, in particular in chapter 9. You talk about judicialization and the colonial tradition, or to be exact, post-colonial constitutionalism, and the relationship between the two. Can you talk more about your views on the relationship between judicialization of politics and post-colonialism? What we learned from Pakistan, what can other countries in the global south learn? It also has colonial history that brought the rule of law to the local society, better your transformation to judicialization. Sorry, there's a lot there, but basically, your views on the relationship between post-colonial and the judicialization of constitutional politics.
The whole, I find, okay, so in many ways, if I'm allowed to say that, this is a soft post-colonial thesis. It's not. I remember teaching this LLM course a few years back, and one student said, "Why are you blaming everything on the British?" So
because they're to blame.
In some ways, because this is okay. So this is the legal system. It's not just, and hence my, in some ways, one of the core arguments. It's not just the legal system. It's an entire state structure which has, by and large, remained post-colonial over a fairly long period of time. The state system, the state structure, the bureaucracy, the military is very much modeled on the colonial institutions. These ideas seem to have been fairly deeply embedded in these institutions, sometimes even regardless of changing personalities. But a lot of stuff has changed over time. So I think, to me, what is really interesting is that dialectic of the post and the colonial. So what explains the path dependence of these institutions over time, particularly judicial institution and judicial review is obviously my main focus, is what explains the path dependence, the continuing colonial legacies despite the passage of so much time and so many crises and so many disjunctures that have happened in the meantime. But also equally interesting is why change happens. Why at certain particular junctures, some kind of change has also happened. How do these courts become from marginal institutions, for example, to more significant institutions? Why, courts continue to, exercise, power in a particular way, but at the same time expanded on those powers. So how, so it's not just the continuing coloniality, loosely speaking, but it's also how and why at particular junctures there has been change, which is what I try to chart in the book in a very, or not a very, but in a fairly, what I think, deeply contextualized way as to why at particular moments change has happened. How does Pakistan fit within other stories of judicialization of politics? In some ways, by highlighting that point about, or hammering that point about understanding institutions in context, I'm almost forced to say, to some extent, Pakistan is a unique case, doesn't fit in with others, right? Other jurisdictions, even comparable jurisdictions, I can draw a direct comparison with India, but although Pakistan's courts have ended up at exactly the same point, it seems like now, as in India, the trajectory has been very different from my point of view, and the dynamics underlying how the courts got here is, are also very different. But what seems to be fairly common, and that needs to be investigated, and maybe there's another thesis there, because that's what Peter said to me, is like, always conclude with what your next project is. That's a good way of distracting people. So maybe I think there's a very more interesting project here, is because similar phenomena have happened in other former British colonies. I can at least say that with some confidence. If you look at some really interesting work on Myanmar's early post-colonial history, there seem to be a lot of very interesting comparisons. But then, of course, until 1937, Burma was part of British India. If you look at courts in Malaysia, there seem to be some really interesting overlaps, some really interesting work on rule of law on Singapore that has very interesting parallels, almost direct parallels with Pakistan's courts exercise of the more traditional rule of law jurisdiction in the space of police powers and detentions. So there seem to be certain things which are common across the British post-colony. I think that's a fairly big and fascinating comparative project in its own right. But some people are already doing some really fascinating work in that space, and maybe at some point I should come back to that too.
Yeah, next book.
After the DECRA.
Yeah. Well, we're sort of approaching the end of our time, but if there's another question from the floor, I'd be very happy to take it. If not, I might just say thank you once again, Moeen, for that really outstanding presentation, and congratulations on your exceptional book. It's already making a big impact, and I'm sure it will just continue to do so. So thank you very much, and please join me in thanking Moeen.